Hello everyone, my name is Matome Mrotoba from the National Consumer Tribunal, and we are going to know how to file a Section 141(1)(b) application of the National Credit Act after being issued with a notice of non-referral from the National Credit Regulator. First, let's go and find out what is a Section 141(1)(b) application. This is a type of application that is filed by the consumer directly with the tribunal if the National Credit Regulator issues a notice of non-referral in response to a complaint referred to it by the consumer. And there's only one exclusion, and that relates to Section 166. So let us talk about this exclusion of Section 166 of the National Credit Act. So it says a complaint in terms of this act may not be referred or made to the tribunal or to a consumer court more than 3 years after the act or omission that is the cause of the complaint, or in the case of a course of conduct or continuing practice, the date that the conduct or practice ceased. Now, subsection 2. It says a complaint in terms of this act may not be referred to the tribunal or to a consumer court in terms of this act against any person that is or has been a respondent in proceedings under another section of this act relating substantially to the same conduct. Moving on from the limitations, now we're going to speak on the steps involved in a Section 141(1)(b) application. Although you will be filing the entire application at the onset, it must be noted that before the matter is heard on merits, the tribunal must grant leave to the consumer to refer the matter directly to the tribunal. So leave to refer means proving your prospects of success and the importance of the matter to you. Let's get into the steps in the process that must be accomplished in order for the matter to finally reach its stage. So first, you must file the application. The responsible person here is the consumer. They must make sure that they meet all the filing requirements. And once they file the application, then a filing notice or a notice of filing is issued, and this one is by the tribunal after they screen and assess the submission by the consumer. And then once that has happened, then pleadings for the leave application become open. Now this means that the respondent, meaning the person the consumer has complained about, is given 15 working days to answer to the leave application and perhaps try to motivate why the application should not be successful. After this answer is received, then the consumer has 10 days to also provide a reply to whatever new things that the respondent has brought up. After that, we say pleadings have closed, and then we have what we call a notice of set down and adjudication. So the notice of set down is issued by the tribunal, and this is when you are given a date of when this matter will be heard in chambers, meaning from the submissions of the consumer, the main application, as well as the answering affidavit from the consumer that we have spoken about, and the replying affidavit from the consumer as well, are looked into, and then a judgment is issued looking at both of those submissions. And then afterwards, once a leave to refer is preferably for the consumer granted, then pleadings for the merits become open. So the same process applied with the 15 working days and the 10 working days. And then there's another notice of set down and adjudication. This is the final notice of set down that will be issued by the tribunal. And then we go into the merits, where parties will present and argue their respective cases. And once that has been done, a final judgment will be issued by the tribunal. Let us discuss what impacts the usual process. So what could impact this is the late filing of the application for leave to refer to the tribunal. So this would mean once you receive the notice of non-referral and you don't file your application within the prescribed period, then you will be in a position where you have to motivate why we should accept your application despite it being received very late. And other interlocutory applications include late filing for affidavits. So say one has already filed the application and it's complete, but the 15 business days for the respondent to provide an answer lapses, and then they have to motivate why they also filed after the 15 business days of receiving the notice and the application. Another one would be applications to amend documents. So say one of the parties wishes to add to what they've already submitted, then they would need to file an application to amend these. Another thing that may delay the whole process would be a failure to meet filing requirements within all these processes of the interlocutory filings. And this is available on Table 2 of the Tribunal Rules. And the Tribunal Rules are, of course, available on our website, or you can simply email us on registry@nct.org.za to get a copy. So going into the Table 2 requirements, first you have the application type. And of course, the type of application you're filing is a Section 1411B. And of course, as described, it says it's a referral by a complainant following the regulator's non-referral of a Section 136 complaint with application for leave to refer. And now the limitations. So when you have a notice of non-referral, what you will notice is that you are given 20 business days to actually completely file your application with the tribunal. And the forms that are required on D being the main form, that's the form NCR 32. And then the other documents required would be the completed complaint form when you first lodge your complaint with the NCR, as well as the notice of non-referral, and finally the form TIR 30A, normally known as the filing notice. There is no application fee for this type of application, and the parties that should be served and notified would be the person you're complaining about, normally referred to as a respondent, as well as the National Credit Regulator. The documents that are required. So the first document required is the form TIR 30A. Now this is a filing notice, and it should always accompany everything you file because it describes the documents that you are attaching and submitting to the tribunal. And then we have a form NCR 32. This is the main form for the application. And then we have the complainant's completed complaint form that was originally submitted to the NCR. And finally, we have the notice of non-referral that was received from the NCR directing you to approach the tribunal. Considerations when completing Form TIR 30A and Form NCR 32. So the first and most important is to get the citation right, as it assists with enforcement of the judgment and with the case before the tribunal. A tip is that you can check the CIPC or the NCR for the registered name of the other party. Make sure, for the sake of uniformity, that the correct citation is consistently reflected on all application papers. Then ensure that the order sought is an order that we as the tribunal can in fact grant. And then you can have a look at SAFLI for tribunal judgments in this type of application to guide you. And finally, you can review Part F of the application form to ensure you submitted all the documents. The NCR Form 32. So when completing this form, please ensure that you complete the form in its entirety and you give a detailed description of the complaint. You must also address the reasons for referral in Part 3, the prospects of success, the importance of the matter to you, and the relief you seek and why the tribunal should grant you leave to refer. You should also ensure that you address the reasons you disagree with the notice of non-referral from the NCR. Service. Proper service must be effected before the tribunal accepts the application. Service can be done by one of three ways: personally, via email, fax, or via registered mail. Personal service. The person signing for receipt must include name, surname, and designation. Courier service is a form of personal service. In addition, you can serve via email and thereafter follow that up with personal service to expedite. In this instance, file after personal service was done. Email or fax service. Consent to service must be received. Consent must be specific and relevant to the service of the application. So consent to service would mean requesting from the other party, being the respondent, whether it is okay to send them your application via email. And once they actually grant that consent or simply say yes in the email, then you can officially send them that application via email. Service by registered mail can be done as well. The registered mail must be stamped and dated. Should the service avenues not apply, please contact us for further assistance. Who to serve and what to serve. Notify the NCR and serve them with, at minimum, the application form. Now, please remember that the NCR is at this point a second respondent in your application, and in all forms, they must be cited as the second respondent. And then they must be served with, as we just said, at least the application form. And then you notify the entity that the complaint is leveled against, as well as all other parties affected by the order or the relief sought, and serve them with all documents in column D and E. Now an insight on what we do when we receive your documents. So we screen your submission and decide to issue a notice of filing, that is, if we are satisfied with the submissions. Alternatively, a notice of incomplete filing with advice, corrections, and recommendations for your applications that will help meet filing requirements. And we do this to ensure that you are able to provide all the relevant information for the tribunal to adjudicate on your case. The common errors that result in a rejection of your filing. The first, not citing the respondent correctly. The respondent must be cited fully and correctly. The second is not completing forms fully. The entire forms must be completed accordingly. Third is serving via email without consent to serve. The fourth, when serving by hand, not including the recipient's designation, signature, date, and time. The fifth, not stating the section of the National Credit Act that your case is based on. The sixth is filing outside of the 20 business days. And the final one is not addressing leave to refer on the main form, being the NCR Form 32. That is how you file a Section 141(1)(b) application after receipt of a notice of non-referral from the National Credit Regulator. And good luck with filing. Thank you.